So nice to see everybody this morning. All right, everybody, it's 10 o'clock. We're going to get started. So today we're talking about the buyer broker agreements, the post-Sitzer-Burnett lawsuit settlement that was announced. We're going to go through the settlement a little bit, and we're going to talk about these buyer broker agreements and how you can use them to really enhance your practice. I'm very excited. I'll start off. We got a lot of people on the call. There were over 800 registered, and looks like people are still coming in. So the way I'm going to do questions is a little different than usual. I'm going to keep everybody on mute. And if you have questions, put them in the chat or raise your hand in the Zoom program, and then I'll call on you and unmute you. So we're going to dive right in and get started right away because we have a lot to cover today. So right off the bat, of course, I am an attorney. So we start with a disclaimer that I am going to be providing you some information. This does not constitute legal advice, and it does not create an attorney-client relationship. You can always call me and we can help you with your practice, with going through the forms, with any of those things. But moving right along. A little bit about me, just so you know who's talking today. I've been an attorney now for 20 years. I specialize in real estate law. Probably most importantly for today's conversation, I serve on the Naples Area Board of Realtors and the FRBAR committees that draft the contracts. So I have pretty good familiarity, you might say, with the contracts. I've been on the board NABOR Legal Resources Committee coming up on 10 years, and I just joined the FARBAR Joint Committee. I assume, but have not heard, that we will be heavy into the buyer broker agreements on the joint committee here when things get started on our next meeting. A little bit of what we're going to do today. Oh, by the way, I do have a title company. So for those of you that don't like to use lawyers for closing, you can always call me and we'll have your closing go through my title company. A little bit about what we're going to do today. We're going to talk about the Sitzer-Burnett settlement. We're going to talk about the buyer broker agreement forms that are put out by the Naples Area Board of Realtors and the Florida Realtors. And then we're going to talk about some tips and tricks that I have learned in 20,000, almost 20,000 closings. One thing I do want to mention right off the bat, these agreements that we're going to talk about today are titled buyer broker agreements, but I want you to think of them more as a buyer representation agreement. It's really important that you start thinking about how you're going to represent your buyers in a more comprehensive fashion if you're going to continue to work with buyers in this post-settlement era. And let's talk about this settlement and what it means. One thing I do want to say as I watch the comments come up, I will answer them all, but we're not going to get into any realtor politics. We're just going to talk about the facts and what happened and where we are and how to move forward. Just a little bit of an overview. Obviously, new period of uncertainty for real estate agents, particularly buyers agents, and the industry is trying to digest this. I'm sure you all are on your social media channels seeing the commentary, the videos, the experts come out. I'll tell you right off the bat, I am not a mass litigation expert. I am a real estate attorney. I do transactions and I think about things from that perspective. So that's what we're going to talk about today. But these buyer agency agreements are going to be essential, and they're actually already required in several states in some form or fashion. And then just a little bit more about the lawsuit. Basically, for those of you that are not aware, the National Association of Realtors and some of the largest franchises were sued in antitrust. And basically, the case alleged that NAR and the brokers conspired by enforcing the cooperative compensation rule to prevent buyers from negotiating their fees. Whether that's accurate or not is not relevant, but that's what was alleged. And of course, the Department of Justice is heavily involved, and they're pretty much getting what they've been asking for. They want and got a prohibition on a seller compensating buyer broker directly without disclosure. Really, that's what it is. Their fear of steering. So we'll go over it. Where the case is now, obviously there was a verdict on October 31st in Missouri. They found NAR and several brokers liable of colluding to inflate commissions. They awarded $1.785 billion in damages. The plaintiffs in the case have asked for that to be tripled to over $5 billion and asked for an injunction. And then, of course, on March 15th, 5 days ago, NAR announced the settlement that we're talking about. Right here in big, bold, italics, underlined. I wish I could put flashing lights on my PowerPoint. The settlement is subject to court approval. This is very, very important because the court and the Department of Justice are all going to weigh in, and the final settlement is not in stone, which is why I'm not going to spend a whole lot of time other than to give you the basics now. One thing I mentioned did happen is the plaintiffs have asked the court to award them $4.7 billion just from Berkshire Hathaway and their companies because they didn't settle the case. So they may end up paying the balance. We will see. Part of the settlement terms, NAR does not admit liability. There is a release of liability for NAR members, state and local associations, and brokers under $2 billion in total transaction volume, and there are others that are released in the settlement. Buyers agents will have to negotiate their commissions directly on each deal. Of course, this is what we're talking about. You know, the NAR agrees not to create any rules, allow listing agents to set compensation for buyer brokers, and offers of compensation will not be displayed anywhere in the MLS. I know at least one brokerage told their people that they may be able to put it in confidential remarks. As I read the settlement agreement, that's probably not going to be allowed. So we will see how that specific item shakes out. NAR is going to pay $418 million over 4 years. They're signing a promissory note secured by all of NAR's assets, which I believe is over $1 billion. Then, of course, the most important to you as realtors is conspicuous disclosure to the seller and seller's approval of any payments that go from the seller or the listing broker to the selling broker or the buyer. That includes concessions, seller concessions for closing costs and things like that. Realtors will disclose to buyers and sellers that the commissions are not set and are fully negotiable. This has to be conspicuously done as well and in writing. And then there will be mandatory buyer broker agreements starting in July of 2024, which is, if these changes are accepted, they're likely to go into effect in 2024. So who didn't settle? The biggest brokerages, if they have more than $2 billion in transaction volume, they can pay a percentage of their sales. So basically $2 billion equals $5 million in payments. And then Home Services America is not a party to the settlement agreement, and they are still litigating. So that's kind of a big deal. I have a mantra that I live by. You don't bet against Warren Buffett. So I would say this is not over. We will see what happens. He is going to the Supreme Court to challenge the fact that they are even in the lawsuit. So we will see where that goes. That will take a couple of years to settle out. And then Remax, Keller Williams, and Anywhere already settled, so they are not covered by this settlement agreement either. All right. So what's next? Again, not released. Home services and large corporate defendants were not released. The court has to approve the settlement, and the rule changes will go into effect mid-July of 2024. So before I get into the buyer broker agreements and what all this means, I'm going to go through the questions and see if we have any that we can answer at this point. But this really is a great opportunity for realtors. Buyers want representation. The studies have shown they want representation. So you need to get ready for them. The forms that I'm talking about today definitely will be updated. But if you send me an email, I will keep you updated as those things come out. And I put on here a little graphic. You agents provide an amazing service to buyers. They don't know what they're doing. And there are more than 105 ways that you provide value to your buyers. But start with this publication by NAR. It's a great sales pitch for you to show your value. All right, before I switch over to the agreements, let me just go through the comments real fast and make sure that I haven't missed any really important questions. Good morning, everybody. Susan, you're asking if you can leave NAR. You can always leave NAR. That's probably not a good idea. The settlement protects NAR members as of a certain date. And I'll have to look and see what that date is. How does this affect open houses? How does this affect veterans if buyers paying commissions? Well, if buyers are paying commissions, we're going to have to figure out how they can afford it if they're a first-time home buyer. I think that's the biggest thing. If you're a first-time home buyer, you're getting 100% VA loan, you're an FHA buyer, and you're putting 3.5% down, and you got to pick up another X percent for commissions, it's going to be tough. It really is. So we're going to have to, that's one of the things that the industry is going to have to figure out is how do buyers agents represent buyers and get compensated because they provide a very valuable service. I'm not going to get into the whole Zillow MLS thing, but yes, that's an issue. Donnie, you're asking about dual agency in Florida. Probably not likely. We use transaction brokerages, so that's probably not going to happen in Florida. I'm not hearing anyone talking about it. Stephen is asking about exodus from NAR. I don't know. I think NAR provides a valuable service. Can't hurt to be the largest lobbying operation in Washington, and I think there may be some ways to go through that to get this fixed. We will see. Let's see here. And Michael, you're exactly correct. Co-brokes aren't going away. They just can't be advertised in MLS. So let's see here. I see a lot of posts still coming up, but we're going to dive right into the agreements. So both FRBAR and NABOR agreements are valid across Florida. So you have your choice. Obviously, if you're in Naples, where I live, you are probably going to use your NABOR forms, but they are valid across the state and they are in form simplicity. They have FRBAR and NABOR's forms are very different and they will be tweaked, I'm sure, because of the mandatory disclosure requirements of the settlement. So this is the forms that we have right now. Just know they will be updated. And again, I will keep you updated as they come out. But let's dive right into the NABOR form. Number one, put your buyer's name on there. Should be fairly easy. And put your brokerage. Enter the full name of your brokerage on the, enter your full name of the brokerage right here. And make sure you don't use any nicknames. I know we all have nicknames and short versions of our long brokerage names, so make sure you put the full brokerage name. What does the broker going to do? This buyer's broker agreement, this buyer representation agreement clearly outlines what you're going to do for the buyer. So when you're talking to them, you can walk right through the agreement and say, this is what I do for you. You help them acquire an interest in or right to use real property. You're going to go shopping for them. You're going to find them properties based on their criteria, and you'll present them to the buyer. And then you'll negotiate the contract and monitor the deadlines. These are the basic outlines of your role. If you think about it, negotiate the sales contract, how hard is that? That is a very difficult task, and it takes the best realtors to do a good job of it. Monitoring deadlines, of course, my title company and I will help you do that, but still, you'll want to work with your buyers to make sure they know what's going on in the transaction. One thing that the NABOR agreement does allow, and Farbar does as well, the buyer understands that other potential buyers may make offers on or purchase through the broker the same property. So make sure that you understand that your broker, especially in a transaction brokerage situation, is able to sell the same property to a different buyer. And that's allowed by this agreement. Okay. The brokerage relationship, again, you have single agency, transaction broker, no brokerage relationship, and you would write the type of transaction agency or the type of agency in the space here. The default is transaction broker, and you need to check with your broker on this. I'm sure, especially now post lawsuit, you pretty much are all going to want to be transaction brokers, because you're going to have listings and you're going to want to show them to buyers who are going to be calling you directly. So be very, very careful. The buyer's role. What is the buyer agreeing to do? This is really important. The buyer agrees to work exclusively with the broker. This is going to be a tough one, but you want them working with you. They agree to refer all inquiries about the property to you. They agree to provide you information about themselves and their financial situation so that you can find them the appropriate properties. And they agree to tell other brokers that they have signed up with you in an exclusive buyer broker agreement. So that is a very, very important term of the agreement. So NABOR sets the term at 180 days unless you enter a start date and a completion date here. And then this is very important as well. The agreement automatically extends if you are in contract, and there is a protection period so the buyer can't go behind your back and better deal you later. And a lot of people are asking, I will put all of this on my YouTube channel and send around the slides after the presentation. So don't worry about that. So broker compensation, obviously very, very important. You're going to check the box here, put your percentage of the purchase price here. And if your broker charges a flat fee, you'll put that here. Or maybe you're just going to start charging a flat fee. That would go here. Yeremi, if the buyer goes to a different agent after signing this agreement with you, you still get paid. That's a great question, Yeremi. You still get paid if they go try to go behind your back. You are entitled to a lien on the property, and you can sue them for the commission. And then he said, who's paying the buyer at closing? Emily, the buyer may pay, the seller may pay. That all has to be worked out in advance. That's another great question. You'll be negotiating your commissions in advance. And when you're dealing with new construction, Liz, that is the same thing. You have to call the developer, find out what they're paying, and it won't be in the MLS. So you have to figure it out with them and get it in writing. Okay, so then the additional terms, more protections. If the buyer fails to pay the broker's compensation, the broker gets a lien on the property that they bought so that they can go after their commissions. Now, whether this stays in, whether this is popular is a big question. I can't say. I know NABOR is working on this form, and that may be something that changes. You are held harmless from making referrals in this agreement. Very, very important as well. So when you send out the inspectors and all those things, you are held harmless for any damage they do to the property. And of course, you get attorney's fees paid if you win a lawsuit against your buyer. Also very important. Lee is asking if you need to use this. Lee, you're going to want to use the standard forms. I can draft you a custom form, but these standard forms are pretty good. And then signing. So this is an important part here. Broker signs this contract right here. Your name goes here, but it's your printed name because the agreement is with your brokerage. So make sure you understand that the broker signs the agreement and they put your name on it. All right, let's go through some of these questions, then we'll switch over to FRBAR, or to FRBAR. So, would the agreed commission, if paid by the seller, be noted on the contract itself? Fatia, you have to now state conspicuously and in writing that the seller is paying all or part of the buyer broker compensation. I can't say that enough. It will be in writing. It has to be conspicuous. The seller and the buyer are going to know where the compensation is coming from. If you have an LLC, Vanessa, yes, you would put it in the LLC name. Diane, I don't recommend either the FRBAR or the NABOR forms. It's whatever you're comfortable with. But the broker has to sign every single buyer agreement. That's right, Jeff. Karen is asking if a buyer contacts you as the listing agent directly, does the listing agent have to have some sort of buyer agreement? Yes. Yes, you do. If the buyer comes to you, you still have to sign an agreement with the buyer, even if you're the listing agent. Rosemary, you cannot put anything in the MLS, is my reading, but I know some brokers don't agree with that. And Marcus, yes, the listing broker can still pay the buyer broker commissions, but it has to be disclosed in writing. And you cannot do that. You cannot just write seller agrees to pay X. It's got to be buyer agrees to pay X, and then the seller can pay up to that amount. Laurel is you're asking if a buyer they cannot terminate the NABOR agreement, and we'll get into that with the FRBAR agreement. That is terminable. Yes, Carrie, you're right. The buyer and broker have got to sign the agreement, and this agreement has to be filled out. I was trying to find in the settlement agreement, it has to be filled out prior to taking anybody on a showing. And I know it's in here. Before the buyer tours any home, the buyer broker agreement must be filled out. You cannot do that, Derek, what you're saying. You cannot list your commission in the MLS, and you cannot put the co-broke in the MLS anymore. That's the biggest thing. Okay. And you could, Kristen, mix the forms. Okay. Yes, Trish, this is another great point. Trish is asking if you have a signed agreement for 3% and a builder is offering 5%, does the agreement supersede? Well, if the property is in the MLS, then this agreement controls, and it would, and the buyer broker agreement would supersede. And the current listing agreements are going to be changed, Susan. The commission should not be in showing time. It says the agreement is, you guys understand, the agreement is very broad. It's more broad than a lot of brokers, a lot of people online are saying, because it has language in here about reading the spirit of the law of the agreement. So I would not spend a lot of time trying to circumvent the agreement by posting co-brokes in other places. That's probably just going to get you in trouble. Okay. So let's talk. There's one other form that NABOR puts out, and I'll get into FRBAR forms in a minute, but there's one other form that NABOR puts out, the buyer agreement for broker compensation. This is a very simple agreement. The buyer understands that the closing of any property purchased by a buyer through the broker means the broker gets some form of compensation, and you simply write the amount that you're going to be paid here. It's like a flat fee. I'll go back into more of these questions, but I see a lot of coming up about the FRBAR agreement, so I'm going to go ahead and get into FRBAR, and then I'll come back. So let's break down the FRBAR agreement. Okay, first of all, FRBAR provides 4 versions of their buyer broker agreement. Sections 1 through 11 are the same on all 4 versions, and then section 12 delineates the type of relationship, whether single agent, transaction broker, no brokerage relationship, or the consent to transition to transaction broker. So we'll go over the first 11 sections, and then we'll section 12 is the same. Again, on the FRBAR form, like NABOR, you put your buyer here, and then you put your brokerage name here, and the office that you work in here. So there's 3 blanks on this page. And you enter the broker's name, this is an exclusive right to work with the buyer to negotiate for property, and they define acquire broadly to protect you. The term of the agreement does not have a default, so you have to enter dates, the start date and the termination date. Don't skip this like you can in NABOR. The great thing about FRBAR that I like is it gives you the opportunity to have a conversation with your buyer about the type of property that they want, whether it's a condo, single family, HOA, no HOA, where do they want to be? And I would be a little bit more specific here than Naples or Collier County or Fort Myers. I would say something more along the lines of the neighborhood or the area. Then you ask the price range they're willing to spend. And then this is really good. The buyer has been pre-approved or pre-qualified for a loan. You put the loan terms here so that you have an idea what they're going to be able to afford. And then you put your preferred terms here. 3 bedroom, 2 bath, whatever it is, whatever their preferred conditions are. So this defines your job, I think, a little bit more clearly. You're going to use your professional knowledge and skill. You're going to assist the buyer in determining their financial capabilities, but you're not going to give lender advice. You're going to discuss property requirements, locations, suitable properties. All the stuff that you're used to doing is laid out, and it gives you an opportunity to talk to the buyer about it. If you are a single agent, you would need to sign a transition brokerage form, Vanessa, to get this done. But you would go in, change over, and then you can use these forms. You protect your buyers who want to engage in FHA violations. You are protected against that by the fair housing rules, and you are relieved of liability for making referrals. What does the buyer do? Again, it lays it out, I think, a little bit more clearly maybe than the NABOR form, but they agree to cooperate with you. The buyer will conduct their negotiations through you. They will advise other realtors that you are their realtor, and they'll provide you accurate information. And this gives you the right to run a credit report on your buyer to make sure that they can afford the houses that you're showing them. And you are indemnified while acting on their behalf. Interestingly enough, this is going to be very important and I think very helpful to some buyer's agents. You can request an upfront, non-refundable retainer. You can go to your buyer. I will take you in my car. I will show you houses. I will find houses. I will negotiate contracts. But I want some money up front, which will be credited to you or may not be credited to you when we close. I think that could be this provision may become more useful. So how are you paid? Again, you pick a dollar amount or a percentage, and or you pick a dollar amount or a percentage over here plus a fee, and that's your purchase. There are options are available. JJ, if you take a retainer, JJ, I would take it into operating because it's a non-refundable fee. And then you are due the commission if the buyer defaults. If they enter into a contract, if they subsequently exercise an option, if they default, the compensation is due immediately. Okay, there's a protection period in the FRBAR contract as well. If they go and try and buy a property that you've shown them and they don't have another broker, then you are entitled to get paid. I will come back, and don't worry, guys, I'm going to come back and answer your questions. We're going to scroll back through the chat. I see a lot of questions, and I will get back to them in a minute. So the next section here allows for early termination. This is very interesting. I saw a couple questions about this in the chat. The buyer may terminate the FRBAR contract early, but they don't get out of paying you if they go back and buy a property that you showed them during the term of the contract or the protection period. And then, of course, dispute resolution starts with mediation. And if your brokerage is purchased, you can assign this agreement. All right, so then they have the broker relationships, and please check with your broker. You don't want to be a single agent to a buyer when the listing is in your brokerage. That will be very bad and a violation of state law. And remember, single agency has to be in writing. Okay. Then we have the signatures. In this case, the associate, the sales associate, you, the realtor, you sign the FRBAR agreement, and your broker signs the FRBAR agreement. So be very, very cautious there as well. Okay, before I get into some tips and tricks about how to get this done, I'm going to go back through the chat, and we're going to talk about some of the hundreds of questions you guys have posted. Okay. Let's see here. Jackie, you're asking, is there a specific way the particular properties need to be documented before shown to correspond with buyer-broker agreement? Jackie, that's an excellent question. Yes, you should always document what you've done with your buyer, and you're going to need to do it even more so. Send them an email. I hope you enjoyed looking at 123 Happy Street today. Thank you for taking the time to walk it with me. If you wish to purchase this property, please let me know. Send them an email, make a record. That's absolutely going to be critical to protecting you should they try to come around behind you and buy it out from under you. If Bonnie is asking, what if seller agrees to pay buyer commission? So let me be clear, that is absolutely allowed. The seller can pay the buyer broker commission as much as they want. It just has to be in writing, conspicuously told to the buyer and the seller prior to engaging in the transaction. So don't think that you can't have co-brokes. You just cannot have them in the MLS. Okay. If the buyer goes to an open house and buys with that listing agent, do they have to pay per the buyer's agreements if they didn't show them that particular home? Bhatia, that yes, they do. If the buyer signs this exclusive agreement with you, and then they go try to buy another home that you didn't show them, you would still be entitled to compensation under these agreements. And that's right, Christy, the base of this, there'll no longer be agent shopping. You, just like listings, sign up for a certain amount of time, and it's an exclusive relationship, and it's your listing, and you sell the house. Now you're going to buy houses. It's the same thing. And yes, I'll be doing this presentation again, Christina. So Trish, it doesn't matter. These are suggestions on the form. He said, what if the property type or location differs from the agreement? You will have a conversation with your buyer over the course of the representation. If you take them to a different house than what they wrote down as the type in their property and description, you would still get paid. And Matt, you're exactly right. It's a great protection when your name is forgotten by as they walk into a builder's office. And Kat, you're asking if the FHA will allow buyers to pay the commission fee. I think that Fannie Mae, Freddie Mac, the Fair Housing Administration, all those rules are going to have to be reviewed in light of this settlement and what can be paid. if you're a first-time home buyer, and you barely can afford your 3.5% for your FHA loan, how are you going to come up with more money to pay your buyer's agent? It's probably going to have to be financed. Let's see here. Can you offer a bonus on MLS instead, Daniel? I would not do that. And you ask here about why would you put their tax ID number on here? Because you want to go after them if they are gypping you on the commission, and you'll need that. Listings, Linda, what happens if listings are secured before this goes into effect? So you have to disclose under the agreement, under the settlement, you would have to disclose if you're paying buyers any money, but that's already in the listing agreement. So I wouldn't spend a lot of time worrying about that, Linda. If you've got listings, they are still valid, and you still have to, you still get paid. Celine, you're asking how best to verify on a record of a selling commission if it's being offered. That's a great question. Just like commercial, your first call is going to be to the listing agent now and say, what's the co-broke? And get it in writing, get a letter, what the offer of co-broke is. If your buyer is serious and you're going down that path, you're going to have to negotiate your commission up front in front of everybody. Buyer, seller, listing agent, selling agent are all going to know what's going on. Let's see here. Bonnie is asking, are we legally allowed to tell the seller they will get more showings if they cover the buyer's agent and possibly get a better price? Bonnie, absolutely. I think that's a conversation I would absolutely have with my seller. Hey, seller, listen, you're going to pay me X percentage. I'm going to offer Y percentage to some buyers' realtors to get them to bring me buyers. It broadens the appeal. It costs you no extra money, but you absolutely are going to want to continue to have that conversation. John, as a transaction brokerage, will the full commission be paid if the buyer uses another realtor if I'm already representing the buyer? Well, John, the commission goes to the brokerage, so that'll be between you and your broker. Scott is asking, can I sign 2 buyer agreements with different brokerages in 2 different locations at the same time? That is a good question, Scott. Can a person go in Henry County and buy property up there? The way this reads, it says it's exclusive. I would say the answer to that question is no. When they sign up with you, you are their agent for Florida, just based on the plain language of the contract. Okay. Are we allowed now to put the commission percentage on the purchase agreement? Well, really, David, the commission doesn't really have anything to do with the purchase agreement. That's between the listing agent and the seller and the buyer and the buyer's agent. Now, if there's a co-broke offered, that would be between the agents and would be writing and disclosed to the parties, but it wouldn't necessarily go on the contract. Again, Trish, with the VA buyers, they're going to have to change their rules, or VA. This is what's really bad about this is the people that get hurt the most are veterans, first-time home buyers, and low-income home buyers. So it's going to be tough to get through all this. Let's see here. All right, let me go through some tips and tricks, and then I'll unmute everybody and we can have a conversation. So basically, I have been a lawyer for 20 years. I've been doing real estate closings for 15 years. I've done almost 20,000 transactions. And this is what I have come up with for you as buyers agents to stay relevant post Setzer Burnett. Number 1, stay educated. Smart people always succeed. Buyers need to be educated. You need to be educated on what they want to know. You got to have local market knowledge. You got to know the inventory. You got to know the options. You got to know what's in their range when you ask them. You got to know how to make offers, processes, forms, and contingencies. You got to know all this stuff. how to handle all of these issues, how to deal with inspections, financing, closing costs, local customs, insurance. I mean, insurance is the biggest problem in Florida right now, not buyer broker agreements. We all know that insurance is insane. So have a good insurance guy on your side and be prepared to give advice, consult, and provide insight on all things real estate all the time and anytime. That's the most important. Stay educated. Be accessible. You know this market moves fast. We know this. We've seen post-pandemic how crazy it is. It's a 24/7 job. I found this quote: "There's no other profession with the burden of accessibility and availability does not receive any compensation for their time up front, no matter the ultimate outcome. Perhaps this will change with the use of buyer agency agreements." So think about that. What does this mean? You're going to be signing up an agreement that says you get paid if you find them a house. So find them a house. People are asking about open houses in here. Open houses are no different. If you're holding an open house on your listing and a buyer walks in and you want to be their agent and sell them the house, you're going to probably have to sign a buyer broker agreement. That's not 100% clear yet, but that is the spirit of what this settlement says. So I know everyone's asking about open houses, but I would say that when you come into an open house, if you're going to show them other properties specifically, but if you're going to be their agent for this property, you're going to need to sign a buyer agreement with them. Okay. And learn to do research, by the way. You're going to have to know a whole lot about all your associations, HOA information, litigation against the associations. You know, learn how to check with the building department so that you can answer questions about permits. And of course, you can always call me. We'll pull those for you. Have a good insurance agent. As I just said, insurance is crazy now. It's really expensive if you can get it. So you got to know about insurance. I would learn how to read deeds and surveys, and you can always call me and I will happily walk you through any questions you have on this. But just be aware of how to do these things and be the source of the source. The source of the source. And the name of the game is reputation. You know this because you guys have been doing this a long time. If you're a known agent and you call a listing agent and your name is such and such and they know you, that helps you. And be an indispensable resource. One last quote I'll leave you with, and we'll get into questions. It's a comprehensive, buyer's rep is a comprehensive, involve ongoing communications, being proactive, problem solving, troubleshooting, double and triple checking, following up and assuming nothing is as it has been purported to be. They don't know what they don't know, buyers. And those who don't have representation are going to be in a problem with serious financial implications. This is your value as a buyer's agent. They don't know what they're doing. They have no idea. And if you're smart and educated, you'll be good. All right, so you guys have asked 100 questions. I'm going to go through them and answer, and then I'll start unmuting you. If you have a question, you can raise your hand and I'll unmute you. Let's handle it that way. So if you have questions, just raise your hand in the Zoom, and I'll come to you. Okay, but let's go through some of these. So Jennifer is asking, how can the buyer ask for a seller credit to pay their buyer broker compensation in the sales offer? How would that appear on the sales contract? Jennifer, it's a great question. It's just like now. Closing cost credit, buyer commission credit goes in the other terms and conditions or the additional terms on the FRBAR forms is what they call it. Write it right in there. Seller shall pay X as a credit at closing to buyer or buyer's agent. Real easy. Do buyers need to travel with proof they're working with another agent? Well, that would be wonderful, Laurel, if they did that. Probably not going to happen, but hopefully they will at least be honest and tell that when they go to other open houses, will tell that they have an agent. Anything in the MLS, Jennifer, does this new buyer agent form affect vacant land as RV sites? If it's in the MLS, you got to use a buyer broker agreement. Tom is asking, at an open house, you're the listing agent. How can you be both sellers and buyer's agent? You do that all the time. It's called transaction broker. You have the listing, you represent the seller, but you're working with the buyer to prepare an offer, and you would sign an agreement for both. Let's see here. All right, Yvette, what is your question? Go ahead, Yvette. Yvette?
Okay. All right. Thank you. I wanted to know or make sure that the buyer's agreement isn't related to the contract that you might write. So if we're an agent, can we have the buyer sign either the FRBAR or the NABOR buyer's agreement? And then it doesn't matter
across the state.
So we can use a FRBAR, but then write a NABOR contract.
Yes, yes, you can do that. Yes.
Thank you.
They don't relate. Yeah. Okay. Ray Cully, you had a question? Ray?
Hello.
Hi, yes, you had a question?
I was wondering if how enforceable are these forms right now? Because in the past, when we tried to use buyer broker agreement, they were not enforceable.
I've not seen any cases that says they're not enforceable. They're a contract like any other. So I would say they are enforceable. If you're aware of a situation where they were found not to be enforceable, let me know and I'll research it. Okay. Susan, you have a question? Go ahead.
Yes. What if, your buyer agreement says the buyer will pay X amount, for your commission, but then later on you find out that the seller offers more of a commission. Are you tied?
That's specifically addressed in the agreement now. You get paid what the buyer agrees to pay you, not what the seller agrees to pay you.
So even if the seller paid more, you could not, get that more. You have to go with what the buyer.
If you renegotiate with everybody and sign amendments to your agreements, you could do it that way. But you can't just say buyer's paying X, I agree to Y, I agree, the seller's paying Y, I get Y. No, you get X. That's specific. That's specifically in the settlement agreement.
Okay.
Susan, you have a question? Susan?
Hi. Yeah,
Yep.
hi. I was going to ask the same question that last question that was just asked. If the seller was giving more, can that money go to the buyer?
No, not unless the buyer's broker exclusive agreement is amended, is what I would say.
Okay.
You would have to go back to your buyer and say, hey, the seller's agreeing to pay X. You and I talked about Y and it's in our agreement. Do you mind if we bump it up to X? And the seller will pay it. You can have that conversation, but you're gonna have to amend your agreement.
Okay. All right. Thanks.
Yep. And then Annette, you had a question. Annette?
Hello, hi everyone. Quick question. As you know, buyers may get discouraged if they have to pay their agent's commission, especially if they don't have enough money to cover all the expenses with the high interest rates and everything. Probably the best way would be to include in the loyalty agreement, the buyer's agreement, that the commission is going to be presented in the offer. My question is, do we need to include a commission in the buyer's agreement, or just include the fact that the commission will be included in the offer to be paid by the seller?
Annette, that's a great question. That is also specifically addressed in the settlement agreement. You cannot do that. You have to put the percent, it's because not the percent, it could be in a dollar amount, but it has to be conspicuous and clear. And it can't be, you cannot write, actually say it in the settlement agreement. If you can see this, it says it right there. It says right in the agreement that the buyer broker compensation shall be whatever amount the seller is offering. You can't do that.
Oh, so you need to include a specific percentage or
dollar
amount.
Right.
That is going to discourage buyers. They're
That's-
gonna get nervous.
That's exactly correct. Yes. Okay,
Okay,
Daniel, you have a question?
Yeah, I've seen somebody else over here, Sam, ask the same question. What if you put a range, say that you had, that you agree to represent the buyer for 3%, but if the seller's willing to pay more, you can put that in the contract there at the same time.
This specifically says that the realtors may not receive compensation for brokerage services from any source that exceeds the amount agreed to in the agreement with the buyer. So if you put a range in the agreement, I have to think about that. That's a good question. I'm not sure I can answer that immediately off the top of my head, but if you say I'll pay you between, I don't know, X and Y percentage, you cannot say based on what the seller pays. That is in the agreement. That's in the settlement agreement. So you couldn't do that. But you might be able to do a range based on something else. That'd be a tough one.
Yeah, say,
Oops, sorry about that. Dan, go ahead. Go ahead.
yeah, say the buyer agrees to a minimum of 3% and up to 5%. Say if you're selling a DR Horton that has a 5% commission out there. But
I
a
think
minimum and up to.
I think that'll probably violate the spirit of the agreement. I would be very careful about doing that. We have a good question. Mike is asking in the chat, has this proposed settlement has been fully approved? Mike, not at all. As a matter of fact, this has not been approved by the court. It's not been approved by the Department of Justice as far as I know. So we are in a wait and see mode for at least a few months. Okay, Jeff, you had a question?
Yeah, can you hear me?
Yep.
You said that the contract makes you exclusive for the entire state. Let's say the buyer is in Naples and wants to check something in northern Florida, and they just want to, see one home. Are you going to drive all the way to northern Florida for one?
Well, that's probably a situation where you're going to want to save the gas money and work it out to do some type of maybe referral with another agent in North Florida. I would think you would resolve that. But the agents, the agreements are valid across the state of Florida, and they're very broadly written. So yes, you would want to work that out with an agent in North Florida to avoid having to go all the way up there.
So if you refer it out, then your compensation kind of gets nullified and turns into a referral then.
Correct. But there's nothing here about getting referrals. You can absolutely still give and get referrals. So.
But then, the contract says if they buy a house with you, you get 2%. But if you refer it out,
you're probably going to share. That's right.
Okay.
Carl, you have a question? Go ahead. Carl? Unmute yourself, Carl. Okay, Carl, we'll come back to you. Bonnie?
Hi, yes. So just so I understand, let's say that you have 4 showings, okay? And of the showings, when you called for the appointment, you ended up finding out what compensation would be from the seller. Let's say the seller's offering 2% on one, the next one's 0, the next one is 1%. So now you have a buyer's agency agreement, and let's say the buyer agent has agreed to the 1%, even though that seller's offering to pay the full commission, do you have to now back into that? So it's almost like this is going to pigeonhole you, hold you to a lower amount when, you have multiple showings. And some of the showings I could see, like some of the areas, you will have sellers understand this, and the sellers will be willing to pay the full commission. And then you'll have others that, very few, I think, that might just say, no, we're not paying any of it. But so the question is, like with the buyer's agent, is there that agreement, will it be pigeonholing based on forcing them to give an amount? Like if you're on high amounts, that's like sometimes a $100,000 commission. And if it's that bad, there's no way a buyer is going to be signing off $100,000 to give to their agent. That's where we kind of really get into trouble.
You're right. It's going to be a very difficult environment, especially at the lower end. I think more than I think the higher end. If you're, and I'm in Naples, and Naples, of course, is weird and crazy because the values are so high here. I think that if you're buying a multi-million-dollar home, you're probably going to pay a realtor something. It might be a fixed fee, might be a small percentage, but it's going to be a different situation out there. And if you're on the lower end and you can't afford those, it's going to be tough. And it's very clear in the agreement that to the extent compensation is received from any source, it must be conspicuous, it must be specified and conspicuously disclosed. If there, it does say this, so to the question earlier about a range, to the extent that such a realtor or participant, that's you guys, will receive compensation from any source, the agreement, that's the buyer broker agreement, must specify and conspicuously disclose the amount or rate of compensation it will receive, that's you, or how this will be determined. So you could use a formula, I guess, reading this carefully, but it would need to be in the buyer broker agreement up front.
And can you say something like, if seller agrees to pay fee, this contract is null and void, or not null and void because you still need the buyer agency agreement, but this percentage is null and void. So if seller agrees.
No, I would not go that far because it's got to be clear how you are receiving the compensation. So be very careful about that. Oh, who's unmuted?
Sorry, that was me. Okay.
All right, Carl, go ahead.
So what, in your opinion, what is the likelihood of this being approved?
I am not, again, a mass class action expert. I don't know how the state court in Missouri operates. I'm licensed in Florida. I would say that all the speculators think it's going to be approved in some form or fashion. I don't know. I feel like it would be. It's pretty broad. It's pretty fair. It achieves most of the Department of Justice's objectives if you read their statement of interest. So I feel like it will be approved, maybe a few tweaks here or there. I think the bigger thing to watch out for is what Berkshire Hathaway Home Services gets out of the Supreme Court. I think that's the bigger game changer for everybody is what Warren Buffett does. And like I said earlier, I don't bet against Warren Buffett.
Right. So you say, for example, an agent's doing an open house. It's on their own listing, and a buyer walks in and wants to buy the house. They have no. Why do they have to agree to pay anything at that point? Where
the seller is under no obligation to pay anyone.
But in other words, the buyer doesn't have to enter into an agreement with you.
No, but then you would not be their realtor, and you'd be exclusively for the seller, and they would be unrepresented. And
I'm in New York primarily, and we represent buyers. We're a fiduciary. We have additional responsibilities,
right?
And we have, we can negotiate on their behalf. And in a transaction broker state as Florida is, it seems like, how do you demonstrate your value to a prospective purchaser?
I agree. It's tougher than a fiduciary or single agency. To be a transaction broker as a buyer is tougher, but you again come in with a knowledge and experience that they don't have. So if you're dealing with first-time home buyers, they don't know what inspections to get. They don't have a WDO guy on standby like you should, so you provide value in terms of the process and negotiations as much as anything else.
But being a fiduciary to a buyer is not an option.
It is an option. If your broker allows it, you can absolutely be a single agent. We call them single agent, not fiduciary in Florida.
Right. Okay. Thank you.
All right, let me keep moving. Janet, you have a question? I know you have a million questions because you told me.
Yes.
Go, Janet.
Okay, so one of my questions were moving forward, it's obviously confidential remarks. Can we as agents say exactly how much we're willing to contribute?
That was said on a couple of phone calls, but the agreement specifically says, where is it? I'll read it to you. Eliminate and prohibit any, no, that's not it. Yeah, require realtors to A, eliminate all broker compensation fields on the MLS, and B, prohibit the sharing of the offers of compensation to buyer brokers or other buyer representatives as described in this agreement, and any other Realtor MLS field. You cannot, in
Okay.
my opinion, this is my opinion. I know that there is at least one giant brokerage in this country that disagrees with me. I don't want to get cross with them, but I do not think you can put your offer of compensation in the confidential remarks.
Okay, got it. Now, on your listing agreement, if the seller is willing to contribute or compensate the buyer, in this case, where, you know, on the third page, where you divide the compensation. And obviously there's compensation like, hey, I don't mind compensating buyer. I'm assuming that in additional terms on the contract, when, you know, buyer goes under contract, we would have to put seller would contribute X amount, or would that be in a separate addendum between both brokerages or agents negotiating the commissions?
Not sure I'm
Sure.
understanding the question. I mean, basically,
Okay.
if you want to make an offer of compensation as a seller's agent or a seller, it just has to be in writing and done conspicuously, you know, prior to contracting.
In this case, it would go in the executed listing agreement, correct? So once we have a buyer agent that has a buyer that fell in love with the property, they wanted to move forward. How would you negotiate? Where would you put the commission so that way it's clear? Would it be an addendum between the agents, knowing the fact that the seller is already agreeing to compensate the buyer agent on the listing agreement?
If you're the listing agent and the buyer comes to you to buy your property, you would sign an agreement and you would agree to that you would negotiate your commission with them. If you know the seller is willing to pay a certain amount, you could tell them that, but you would still want an agreement signed with the buyer.
Okay, so regardless of that, you know, we could still negotiate commissions between agents if seller is willing to compensate buyer agent, correct?
Right.
Okay, so that would be an addendum, or we would have to put it in the contract?
It would already be in your listing agreement what the seller is willing to pay.
Okay, perfect.
All right.
So we would enforce security for between agents with an addendum? That's my question, because I mean, some agents are gonna want to make sure that they're getting paid an X amount of commission and that it's in writing or somewhere where, you know.
Yeah, you would, you mean between the agents. I get, you would need to do like
correct.
they do in commercial. I would do a letter agreement. If I'm the buyer's agent, my first call when the buyer says, I want to look at this property, is to the listing agent. What's the co-broke? Are you paying it? Send me an email that says you'll pay me this percentage.
A letter agreement or an email works.
Some type of agreement between the brokers, and that may be something that that FRBAR and NABOR have to come up with in terms of forms. That's a good point. I'm not sure how that's going to work, but it would be a negotiation between the agents as to how the co-broke will work. It will not be done in the MLS, and it must be and people are asking, what does conspicuous mean in the chat? Conspicuous means clear. It's got to be obvious. You can't like put it in 8-point font at the bottom below the signature on the agreement.
So moving forward, we will be technically negotiating directly with agents or seeing if we be compensated any broker compensation for representing the buyer agent, correct?
Say it again.
So moving forward, our commissions will basically be negotiated between agents to see if sellers are providing any compensation to
Yes,
see how to move forward with our buyers.
that's right.
Perfect. Okay, thank you.
Thanks, Jen. Okay, Cheryl.
Hi, so I did have a question as well as to if there would be a form to just get that in writing. So you answered that question. And I know this is going to sound like a broken record, but I'm looking at the buyer broker exclusive agreement, the NABOR one. And the very last line of page 1 says, if any compensation paid by the seller and or landlord to broker exceeds the amount of broker's compensation set forth herein, broker shall be entitled to accept any such excess compensation.
That's right. That's going to have to come out.
It's going to have to come out. Okay.
That's my
And then
opinion, by the way. I got to keep saying this because I'm going to get in trouble with all my committee members, but I think that's going to have to come out.
Okay.
Okay.
So right now it's in, but you think it's coming out?
Yeah.
Okay.
All right. Angel, go ahead.
Hi, Sam. So I just want to be clear on the but the new or rather the exclusive buyers agreement. Does it pretty much nullify the need to also have that buyer agreement for broker compensation? You had mentioned it earlier. Do we even need to have that ever if they're signing the buyer exclusive?
Sandy,
Agency.
which one?
Okay, so with NABOR has a buyer agreement for broker compensation.
Oh, the single page form. Yeah, you wouldn't use both.
You would not.
No, because the exclusive, the buyer exclusive agreement. If I can flip back to my slides real fast. Has in the broker comp whether you would put a fee right here. So you have a choice in the NABOR agreement. Oops. Okay. Kelly? Kelly, you had a question?
Yes. Can you hear me?
Yep.
I'm a listing agent and I will have to say, yikes. I'm sure we're all a little confused with everything going on.
Sure.
So as a listing agent, so we're not going to be we'll have our listing agreement. If the seller wants to pay commission, like you said, the commission will be on the listing agreement or the flat fee or whatever they want to pay as far as compensation.
Right.
So in saying that, if we can't put commission anywhere, and we put and we're paying our MLS dues to put listings obviously in the MLS, which is where we want them to be. So every buyer's agent can see them.
Yeah.
So it's more work for the buyer to have to call agents, because of course now there's more inventory, so buyers have more choices, so there's more to see. Is there not going to be anywhere where we can put commission if a seller's willing to pay a commission for a buyer's agent to see?
You're allowed to put those inside your brokerage only.
What do you mean by inside?
So you're allowed to do like the traditional, like we do now, co-brokes, but inside your brokerage only.
So I can send an email or something out to all my agents in the office saying I have this great new listing and the seller's offering 3% or 2%.
My understanding from this is you're still allowed to do that inside, if I can find it.
Okay.
Inside your brokerage only.
Okay. Okay. So, I mean, let me ask you this. So could it be listing?
You may do internal comp offers only. It's in paragraph 5.
Okay. So in saying that, then could our MLS eventually get eliminated and then listing agents?
There are people saying exactly that.
Just start putting things on Zillow, because Zillow, we could probably put the compensation.
You won't be able to. Zillow's a broker.
Okay. So we can't do anything like that.
Yeah.
So
I would not spend a lot of time trying to figure out how to circumvent this rule, because in addition to the language that I've quoted in the PowerPoint and read to you, there is other language in here that say things like, where is it?
I just don't understand why they're making it so confusing, because they always said, communicate, be upfront with your commissions, show your commissions.
That's what they're claiming didn't happen. That buyer, the crux of this case was, in my opinion, that buyers were told that agent services were free, and they're not. Sellers paid them, and that's the bare bones one sentence argument that the sellers in the Seitzer case made. We overpaid because you told buyers that services were free, and therefore we're entitled to compensation. That's the base. You can't do that anymore. That's a simple thing. Sellers and everyone has to disclose. Oh, sorry, I didn't mean to unmute you there. Go ahead, Kelly, unmute yourself. Go ahead, Kelly. Did she go away? Okay. Matt, you had a question? Unmute yourself, Matt.
I'm sorry.
Sorry, Kelly, hold on. Go ahead, Matt.
Okay.
Sam, thank you for doing this. I'm thinking this is probably going to be a series of calls, because right now there's just, we don't have enough concrete details on how some of the stuff is going to work. one of the things I saw popping up in the chat over and over again was the term seller concession to buyer in regards to paying the commissions. You had already said to list the commissions the way, once you get to that part, handling the commissions the same way. The use of seller concession to the buyer is going to have a very different meaning in regards to a mortgage. And we're going to quickly exceed what's allowable.
Right.
One thing Sam and I kind of discussed earlier is that how this is going to relate to any transaction with a mortgage is a mile down the road. Fannie, Freddie, HUD,
Yes.
none of them are proactive. They are all reactive. So none of them are going to do anything until after whatever happens starts to create a problem for them. That's when they'll deal with this. But just avoid seller concession to buyer if we're using that to try to describe what the commissions are.
Right. Someone posted in the chat just now, I think it's a great way of saying it. DOJ wants the buyer-seller compensation decoupled. They want everybody working for themselves. That's the way it's going to be. All right, Christina, you got a question? Christina? Is she still there? Okay. We'll come back to Christina. Joe, you got a question? Joe? Oh, where'd Joe go? Am I doing this right? Asked unmute. Okay. Joe, you still there? Yep.
Can
Go
you
ahead.
hear me?
Yep, there you are.
Okay. Thanks, Sam. Hey, I got a question. I've got a listing. Buyer comes to look at the listing or calls me on the listing. I offer the wording of the buyer's agreement. The buyer does not want anything to do with it. Does not, refuses, I'm not going to sign anything. What do I do? Do I not show the property? Do I
Right,
just
you
throw a
can't show it.
waiver?
It says you got to have a written agreement before buyer tours any home. That's what the settlement agreement says. Yeah, they don't want to sign, you don't want to waste your time.
So they don't want to sign, I don't show the property. The other question I have, if I don't want to work with a buyer other than my listing, can I isolate that buyer to just my listing for that one listing?
What do you mean?
I have a listing, 123 High Street. A buyer calls me on it, wants to see 123 High Street. I don't want to work with that buyer other than my listing on 123 High Street. Can I isolate that agreement to that showing?
I would use the FRBAR agreement and write the address in that on that part where you can describe the property, and I would still let them sign an agreement.
Okay. Thank you, sir.
You got it. You Remy?
Hi, can you hear me?
Yep.
Okay, so my question is this one. So once we have the buyer broker agreement signed, let's say that you either choose a flat fee or a percentage for the compensation. So we speak to the listing agents to all the properties we are going to show. And let's say we put 2% and the seller is willing to offer 3% commission. I want to confirm with you, you said that we can amend that buyer broker agreement specifically for the property the buyers wants to buy?
I would do that, yes. If you sign, because you're going to sign a buyer broker agreement with your buyer before you show them any properties.
Exactly.
And say you show them a property and you find out that the seller is willing to pay X percentage more than what you are already going to be paid by the buyer, you have to go back to your buyer and renegotiate. Because remember, the purpose is there's X amount of dollars in a transaction that it's got to be paid to the listing agent, to the selling agent, to the tax collector, to me, to the title, to everything. So that total amount of money in the transaction is what they're trying to reduce. You know, they're coming after title insurance, they're coming after buyer brokers, everything. They're trying to reduce the total amount of cost to buy a home. That's the goal. That's the policy.
Okay, in this case, Sam, do you recommend that we do the letter agreement between buyer's agent and listing agent? Because there is a thing.
Absolutely.
So
Absolutely.
once that you speak also with your buyers, they know. So they are going to be always, because we all know buyers are the ones suffering the most in this situation. If they can't come up with that money, and then all of a sudden you say, okay, we are going to change this. They probably would like to see something where you are confirming that the seller's agent is the one, I mean, the sellers is the one paying that percentage and not them themselves. I don't know if I can explain myself about it.
No, you're saying it right. Yeah, you want a letter agreement or something, some type of something written between the agents that says who's getting paid for what. And if it doesn't match your buyer broker agreement, you need to amend your buyer broker agreement.
I'm assuming it has to be signed for both brokers, right?
Absolutely.
And another question that I have that I post on the chat. So it will not be allowed in the other terms to write like sellers agree to pay buyer's agent for being the procuring cost.
So this is a point of disagreement between some brokers. As I read this agreement, I do not think that's allowed because it says any other realtor MLS field is prohibited from putting that in there. So you can't go into confidential remarks and put your comp.
Okay.
All right.
Okay. Perfect.
Thanks, Jeremy.
Thank you, Sam.
All right, Christina, you ready? There you are.
Hi, Sam. Thank you. So to piggyback off of the last young lady, example, you have your buyer, you have them sign at 2%, right? Let's say you're dealing $1 million properties, wherever. And then the sellers are they have signed that they will give the 2%. So is there something that says that 2% will be handled by the sellers and not the buyers? The buyers are going to be
That'll
so
probably be something that we have to amend in the contracts to make more clear and conspicuous.
right. So
That
if
would
we
be allowed.
if we do, not to cut you off, but if we do a 2.5%, then something has to be in there like, okay, the sellers have agreed to do a 2% co-broke. Well, then they'll do the 2% and then the buyer would do the 0.5.
Right.
Okay, and when do we think that's coming down the pipe? If we're dealing with people right now, right?
Nothing is in writing, nothing is in stone until this settlement agreement is approved by the court. It'll be
So
late.
we shouldn't even necessarily have to broach the subject with our current buyers right now.
Right.
Because everybody's asking, right? So we just tell them, hey, down the pipe sometime in
Nothing
June
has
or
changed.
July.
Nothing has changed yet. That's what I would say. Say everything is still the same. It hasn't been approved by anybody yet. We're still just talking.
Yeah, so buy right now so you don't have to pay.
Right. There you go.
All right, thanks.
Yeah. Okay. Roger, go ahead.
Morning, Sam. So the scenario would be I have a buyer broker agreement at 2%. We identify 4 properties that the client wants to see. I call the listing agents for the 4 properties to find out if and what the seller is willing to pay. So if the seller says, I'm not willing to pay anything or 1%, wouldn't now my buyer be commission shopping like they're accusing agents of commission shopping?
Probably.
And say, hey, I don't want to see any properties where the seller is not paying the commission.
Sure. And that'd be an inquiry you're gonna have to make.
That defeats the entire person what the DOJ is trying to achieve.
They're also harming the most vulnerable buyers, which you would think the government wouldn't do, but they are.
All right, but I got this right? The client
right.
can ask me, my buyer can ask me, are they paying a commission? What is it?
Absolutely. That's kind of what DOJ wants to have happen so that the commission can be negotiated.
All right, thank you.
Yep. Stephanie, you asked a question in the chat that's very important. So every agent will need a buyer broker agreement before showing property. The answer is yes. Okay. Ray, you had a question?
So it's okay to use that buyer broker agreement right now as well, and it's enforceable, as we just said earlier.
Yes.
The other thing, Okay, thank you for confirming that. The other thing is the percentage that I'm going to get paid by the seller. Should that be specified on an agreement between the two agents?
Yes.
Should that be specified on an agreement between me as a buyer agent and the seller? Or could it be part of the buyer seller purchase agreement somewhere there in the other remarks?
I hate to make realtors third parties to buyer and seller sales contracts. I would rather see you work it out in a letter agreement between the brokers before the transaction gets going.
Okay, just between the brokers, not between me as a buyer's agent and the seller.
Well, you wouldn't talk to the seller because they have their own realtor. That would be a violation of a different rule.
Correct. Okay, thank you very much.
You're welcome. Batya?
Oh, there we go. I'm so sorry because we're going to continue on this. So multiple questions on the commission. If you're saying, if I understood correctly, that if the buyer's agreement indicated a lower commission than what the sellers the sellers were willing to pay, that you must accept then the buyer's commission.
Right.
Okay.
They're decoupling the buyer and seller from the commission process.
But
the buyers get their own realtor, the sellers get their own realtor, and you can negotiate commissions off the MLS, but the buyer has to agree in writing to pay the buyer's agent X% or X dollars or some other compensation for the buyer's realtor.
So if this, two more questions, if the seller had signed off on their listing agreement that they were offering, let's say 2% to the buyer's agent, would then the agent get both the buyer's agreement commission and also what the seller agreed to pay?
Doubtful, probably not. No.
Okay. And would if the buyer does not want to see any homes that the seller's not offering commission, yet they are refusing to, they need to sign a buyer's agreement, then they're never going to see a house because there's
if buyer won't agree, you can't show it. That's what the settlement agreement says.
Yes. Okay.
The buyer won't sign on the dotted line. You can't take the buyer in your car.
So how do you ever get the seller side co-broke then? If the seller agreed to pay, but you must have a buyer's agreement, how do you ever get?
You would have to call. This thing says enter into a written agreement before the buyer tours any home. So you would need to call ahead of taking the buyer out and find out what the co-brokes are.
But if the buyer's also signing the agreement, then how does the seller ever pay it? Only in the form of a concession.
The buyer's agreement can say that if the seller agrees to pay it, it just can't be in the MLS. You can still do co-brokes.
Okay, I'm gonna have to read it a little closer. Thank you.
Yeah. And this question about open houses, by the way, is really interesting because I'm not sure how that's going to shake out. Are you going to need to have a stack of buyer broker agreements at the open house now? That's a really important question. So I'm not sure how that's going to work, but I'm going to do a little bit more research and try to see if I can get an answer. So I see a lot of you asking about open houses. And the real answer is I'm not sure what's going to happen at open houses because this settlement agreement clearly says written agreement before buyer tours any home. So if you're going to walk them around an open house, maybe you're not their agent. Maybe that's the answer. You are not their agent. You are the listing agent. You work for the seller. The buyer is unrepresented, and you would negotiate with the buyer over the purchase price as if you were the seller. Maybe that's the answer. So for all of you asking about open houses, I think it's crazy. I don't think they're going to be extinct, Virginia, but it's going to be crazy. Yes, it's going to be tough, and the rules need to be clarified. This may be an area that should be brought up by NAR in this settlement, in this continuing negotiation with the courts. So that's a really good idea. All right, Scott, you had a question? Scott?
Yes. Hypothetical. I have a listing. My seller has agreed to to pay a commission, but like a variable rate commission. So if my brokerage brings the buyer, he'll pay 4%. If I have to co-broke, he'll pay 5%. As a listing agent, can I go out there and just advertise that? Hey, come to me for a discounted buyer broker, agreement?
That is a good question as well. If it's in the MLS, I would say no. If it's not in the MLS, it's unclear, because the way they do the definitions in this settlement agreement with Realtor MLS and Realtor members and Realtor participants, if you are a part of the MLS, I don't think that you should be advertising your co-brokes, but I'm not 100% clear on that. Because it says the realtor NAR agrees not to create, facilitate, or support any non-MLS mechanism, such as aggregator websites, for listing brokers to make offer of compensation to buyers or buyers brokers. However, they can do it internally. So, Scott, your brokerage, if you have a listing, you could go in an email to your fellow realtors at your brokerage and say, I'm offering 2%, or I'm offering X% or whatever it is on this, but you can only do it internal to your own brokerage. That's what this paragraph 5 says.
But Sam, who says I can't put out a flyer to everyone saying that, hey, come look at my listing. I offer a 1% buyer broker fee. Then I can get the buyers there without another agent involved on a 1% fee. I mean, it's borderline steering. I mean, I just see so many lawsuits happening because agents are going to steer hard now.
Yeah, this is not going to solve any problems. I agree with you in that regard. And again, this thing says that the realtors agree not to create, facilitate, or support any non-MLS mechanism for listing brokers or sellers to make offers of compensation except internally. So that's just, I don't have a strong answer for you, Scott. I wish I did. This is going to still be fleshed out. Okay, Jennifer, you have a question? Jennifer? Hi. You're on mute still. Go ahead.
Yeah, sorry. I know there was a couple of Jennifers in this, so I wasn't sure. Yeah, so obviously I've heard a few questions that I had kind of addressed, that we are basically pigeonholing ourselves with the buyer agreement needing to be signed ahead of, showing multiple properties. They may still have.
Yeah. You're going to have a difficult situation. It's going to be hard to show. Jennifer, are you still there? Looks like she froze. Rosemary? Rosemary, you gotta unmute yourself.
Yes, Sam. I have a couple of questions. You mentioned during the presentation that the FAR buyer broker agreement requires tax numbers on there. So now we as agents.
Yeah, so I would say that's a tough one to say, hey, what's your social security number? But if you've got to go collect against them, you're going to want it.
I understand that, but I knew when I was a HUD agent, having people's social security number put them at liability, put them at risk, and also was huge liability.
Yeah.
I'm sorry?
It's a $10,000 per occurrence fine if you publicly display somebody else's social security number in Florida. Like when I collect people's social security numbers for the OFAC list and all that stuff that I have to do, and I lose those, it's a $10,000 per occurrence fine in Florida.
One other thing is.
Yeah, so be very careful about that.
Yeah, I think that just it's further putting our buyers at risk, further creating problems for our buyers.
That may have to come off the FRBAR form. We'll see what they say about that at the committee.
This whole thing is a cluster mess. One other thing, there was an agent that's already gone into Nextdoor and advertised that he's going to give reduced commissions because of the lawsuit. Now, you and I both know he didn't understand it, but it's already out there, and there are people who are advertising that they're going to do a reduced commission because of the lawsuit. And I have been approached by 3 buyers now that want to negotiate because of this lawsuit. And my response is, this doesn't apply till July. We don't know how any of this is gonna work.
Right,
It's just, you want the property?
right. Yep.
Sort of my response.
Thanks, Rosemary. All right, Kelly, go ahead.
Yeah, you've answered a lot of questions, and I'm so glad you did this today. And I know we're all still going to be very confused. We have to go back, I think, to the old question. Remember when we used to ask people, are you currently working with an agent? Now it's, are you currently working with an agent and have signed a buyer broker's agreement? When anybody comes into an open house, or as a listing agent, when anybody calls me on a property. And if they have signed one, I guess buyers can be liars, but if they've signed one, unfortunately, am I correct? We cannot help them once they've
Right, that
signed
they're
one.
exclusive. They owe a duty of loyalty to their agent they've already signed with. So yes, that's a very good observation. You'd say, have you signed a buyer broker agreement yet?
Mhm.
Yes, I can't help you. No, please sign here.
Right.
Yep.
Okay.
All
And
right,
thank you
Leanne?
for taking your time.
Oh, you're very welcome. Thank you. I love doing this. Leanne? Go ahead, Leanne. We can't hear you.
Hi, Sam. Can you hear me?
There you are. Go ahead. Oops, she muted herself again. All right, Leanne, we'll come back to you. Susan?
Yeah, hey Sam, I think the whole thing that started this, and I have a question with regard, is the MLS have tied our hands through their clear cooperation. They had said to us, even our contracts read, if you are not in the MLS, you cannot advertise, your co-broke or sell to anybody outside, outside of the MLS because of the co-broke. So then that begs the question, if I'm not in the MLS and I don't put that in the MLS, can my own website through my company or my own company have the listing there for the public to see, whoever? I mean, we got to be conspicuous and say, seller will pay 2%, 3%, yada, yada, whatever percentage, because this is all tied to the MLS. But if we're not in the MLS,
If you're
how
not
does
in the
that
MLS, this doesn't apply. That's right. This is
it
for,
does.
this
So
is
we
for
could
NAR
say,
members.
I'm not going to be in the MLS, but here's my website with my company. My listings can have a little section that says, this way, any realtor could go to my website and see on my website all my listings. And in that listing, it could say, seller co-broke, will co-broke buyers, agent, whatever, yada, yada. So that's one way around it, correct?
Well, it's not really a way around it because you're outside the MLS. So you're outside the strictures of the agreement.
Yes. And so that would be one way so that I don't have to worry that,
But you
who's
won't be able to use
paying.
the MLS, which supposedly is the value of
Well,
so.
that's to be going forward if it's worth anything anymore at this point, because buyers agents need that information without making phone calls, getting it in writing, finding out you have to renegotiate your buyer agreement if you're getting a higher price from a seller or not. So ultimately, I think, if I do a website with, my broker or whatever, then I'm exempt from that. It can be posted because they told us.
If you're a member of NAR, your brokerage is, then you're going to be subject to this. So be very careful.
Okay, so it also rests on the NAR. Okay, unless you're your own broker.
If you're a member of the local MLS, you're a member of NAR almost automatically. There are some, obviously, some non-owned. I'm not familiar with all those, but for the most part, if you are on MLS, you're an NAR member.
So it may behoove a lot of people to say, we're done with NAR and we're done with the MLS. Well, people could just go to our website and, here you go. Here's listings.
We're not going to get into realtor politics and NAR rules.
Okay. Well, I just wanted to know what was legal or not,
Okay, Leanne, go ahead.
Hi, Sam. Can you hear me?
Yep.
Okay, great. So honestly, my question was kind of related to what the last guest had mentioned, because, there's so many different webinars and podcasts and all sorts of interpretations of the recent settlement. And of course, with the cooperative compensation not being able to be put on MLS anymore and in any field whatsoever on MLS, there was one area that I read from another interpretation that you can at least post the compensation on a broker website, which I'm understanding that that might not be allowed. Is that something that would be a violation as well, since if you're a member of
not clear, it's not clear in here. If you have a website that's not related, that's not receiving the IDX feed from MLS,
right?
Could you post them and not feed it out to others? Probably. That seems to be okay, but I'm not 100% sure on that.
Right.
The other problem I have is I know the technology exists, but I'm not 100% how it works, the feeds and everything.
Correct. And then the other portion is I saw a couple of people, they would ask like, oh, if you're a Shoami agent or if you're a Zillow Premier agent, and now someone presses on the app, I want to see this property at 11 o'clock today. Now we have to have a secondary step or in between step of signing a buyer broker agreement before we even go out to show.
Yep. That's exactly correct.
Understood. Thank you, Sam.
You got it then. Thank you. All right. Who's up? No, Rebecca, go ahead.
Okay, Sam, thank you so much for doing this. We really appreciate your expertise. My question is to try to make it easier for buyer's agents to learn, the buyer agent commission that a seller is offering. Is it permissible once they make an appointment through showing time to put that compensation in the showing time instructions?
It says any non-MLS mechanism should not be used for making offers of compensation. So what I would do if a buyer comes up into showing time, can they get into showing time directly, or do they need an agent through MLS?
Well, no, I'm saying this is a buyer's agent that's making an appointment through showing time. So they've requested the appointment. So is it permissible then when you're
like
giving them the
in the
showing
message that goes
instructions,
back, you mean?
right, to also say,
Yeah, you could probably put the offer of compensation in that because they've already signed a buyer broker agreement or coming to show your property. Yeah. Again,
well, it's the buyer's agent that's making the appointment. So yes,
yeah.
it's just make it one step easier for somebody to be able to get that information that they need without calling the listing agent to say, hey,
I don't think there's a restriction on how you communicate the co-broke other than you cannot do it in MLS.
Okay. Perfect. Thank you.
Laurel?
Hi, Sam. Couple things. One, as a listing agent, I think that our big fear is going to be that buyers are going to want to come in unrepresented and come up with crazy contracts that we've never even seen before.
Probably. The internet is already full of them.
Right. So, a lot of our listings, at least in Naples, will specify in the confidential notes, please submit offers only on NABOR contracts, whether it's the standard or the as is, whatever it is, but it's something that's already talked about in the listing agreement with the seller of, the pros and cons of different contracts to accept or not accept. Is this something that we are still going to be able to put in there? Because it's my understanding that to get access to these contracts, I mean, you're going to be working with a professional realtor.
You are headed down the path where the buyer's agent provides value.
Right.
Sellers want a standard contract with all the terms in it. I can provide that to you. Pay me money.
Right. So that's my first question. The second question is, I know that you said that there's allowed to be compensation discussed within the brokerage itself to advertise that. Do you think that there is going to be brokers come together and do one big umbrella and then create what is going to be considered like teams under of brokerages so that we can sidestep this?
It'll probably go the opposite way. The big brokerage, I think, are gonna have a tough time.
Okay.
The biggest brokerages and the no comp brokerages where the 100% brokerages are gonna have a tough time.
Okay, and
It's an opinion. I don't have any basis for that yet. I've just been thinking about this for the past 5 days and done nothing else to the chagrin of my children. And I really think the biggest brokerages, the 100% brokerages, are gonna have a tough time.
okay, and then my final thing is,
As Vincent just posted, time to go fishing.
the final thing that I was gonna say is that, you know, with all this additional time that it's gonna take for, if you're working with a buyer, not only do you have to explain the new buyer agreement, you've got to get them to sign it and trust in you and build this relationship. But then you also have to call each one of these listings, talk to the agent, understand what the compensation is. You know, there's going to be a whole lot more steps involved than what we're used to right now. I
Yes.
think
On
in my
the buy side and the sell side, yes.
right, in my opinion, I think that it's going to be really hard for new agents to come in that are not well versed, that do not have a team behind them, and do not have assistants that can help them make these phone calls and navigate. It's a lot easier, somebody who's been doing this for a long time, to say, hey, Jill, I've got, you know, this person, what are we doing here on this? Is the same as, you know, you had with the last seller, and have those relationships really quickly moving back and forth. Then somebody says, I just got my license last week and I'm trying to figure this out and I got a new buyer, that, you know, I think that it's going to do the complete opposite of what it's trying to do, which is
Yes.
make it a bigger, fairer playing ground. I think it's going to make it a super tight, exclusive playing ground where
Yes.
you're going to knock out a lot of
I think a lot of
agents.
realtors are gonna have a tough time. But
Okay.
as we said in this slide, the name of the game is your reputation for getting a deal done. If you can come
Right.
out, I'm Sam Sod and I sell houses, that'll help you.
All right. Thanks, Sam.
You're very welcome. All right, Trish,
Hi, Sam. Thank you for doing this today.
you're very welcome.
Quick question. You were earlier, I saw Lee post a question about custom drafted buyer broker agreements. Could we pay someone like you or another attorney to custom draft a buyer broker agreement that would address some of these items to
Well,
have?
the NABOR and FRBAR are going to do it. I will happily take your money and draft you a custom agreement. But I think that the standard forms are going to be tweaked and they will be just fine. But if you want to pay me, I don't mind.
Do you think they're going to cover things like that, what we were talking about, where
Absolutely, they're going to have to cover it.
broker, if seller offers a co-broke, then that will, okay.
I think we're gonna have to address all that, yes. Okay, Stephanie?
Hi, Sam.
Hi, Stephanie.
My question is regarding the process that would happen in the event that buyer's agent A has the buyer. They don't get along for some reason. They move on to agent B and say they don't have a signed agreement. They close on, let's even say, a property that agent A showed them. What happens in terms of litigation after that point?
Well, agent A sues the buyer for the compensation. They're owed money.
Okay, so agent B isn't liable or unpaid.
Agent B is probably owed money too. Yeah, the buyer tried to double deal, so they're gonna get paid twice.
Okay, thank you.
You're welcome. Okay, Scott.
Okay, so quick question. If a buyer goes to closing and they cannot or choose not to pay the negotiated commission at the time of closing, what happens to the contract?
Well, the contract is between the buyer and the seller. So the contract goes to closing, and again, you sue the buyer for your commission.
So
now,
it would,
the NABOR contract gives you lien rights, so you could lien the property and possibly foreclose if those were going to be upheld by a judge, and that's questionable.
okay, so the closing would continue, and then the agent broker would have to use some sort of litigation to receive their just compensation.
Right. Okay, Stephanie?
Yeah, hi, good morning. Can you hear me?
I got you. Yep.
Yeah, just back to what Lauren asked about the contract. So we have a listing and we get a really uneducated buyer that, you know, writes up a contract in pencil or whatever, and we don't want that. And we say we're only accepting NABOR or FRBAR contracts. Should we charge them for that or just supply it to them, or is that allowed?
That's a perfect opportunity to use the no broker comp sheet and say, I'll draft you a proper contract for $500 or whatever it is. You know, don't use $500.
Okay, thank you.
You're welcome. John? John?
Yes, hi, Sam.
Yes, sir.
Um, I might have missed a couple of questions there, but what I wanted to ask is, doesn't it behoove the listing agent to have the seller still pay for the full commission? It would.
Yeah, I mean, it could make the offer more attractive, you know? You certainly will, if you do seller concessions for closing costs or seller concessions for a broker, for broker commissions to the buyer's agent, you certainly expand your pool of potential buyers. Yeah, so it
Yeah.
does make some sense. You just have to do the analysis.
And the incentive is that if that's the case, then the house would potentially sell quicker.
Yes.
With more considerations going
Exactly.
on that way. And the other thought is, if the listing agent is doing the open house, and I guess other people have said that, the first question is, are you represented? Which was something I guess I was told to do even from the beginning. Are you represented? And then I guess now we need to see a buyer broker agreement from each potential buyer that walks into the showing.
Yeah. You need to say, are you represented? Have you signed a buyer broker agreement? Yes. I have to talk to your realtor. No, please sign here.
Please sign here. So then one can get both sides of the transaction if that's the case.
And that's that. I personally think, in my analysis and understanding and talking to realtors over the last 5 days, listing agents are going to be where it's at. Buyers agents are going to have a tough time.
Yeah. Yeah.
Okay. Brett?
Great. Thank you.
You're welcome. Brett?
Hey, Sam, how you doing?
I'm great.
Couple things I just wanted to bring up. One is, everybody needs to stop talking specific numbers. They need to put X or Y. Don't discuss any percentages numbers wise or dollar amounts. I think we're kind of crossing a line there. But the second thing I wanted to bring up is a lot of the ABR instructors are now being trained very well on what's going on with the Burkett lawsuit and the other lawsuits. And right now, NAR is offering the ABR designation classes for free every month. And NABOR actually has one coming up, I believe, in September. It'll be in classroom. Otherwise, they're available on Zoom. And a lot of the questions people are asking will be answered during that time. Plus the fact that once we get to July and we know where we're at, we definitely will have some more answers. But I really encourage everybody to take the opportunity to at least sit through that 2-day class if they have the time, because it will help them a lot in answering some of these questions.
And I will endorse that as well. Take these classes. You got to be educated in the system. You got to know what's going on. Take all the classes. I see those designations that realtors can get, and I'm jealous. I don't get those as a lawyer. You got to take those classes. That's a great point. Karen?
All right, question. With pre-existing customers, do we now have to go back to everything we've shown them, call every realtor that has had that listing?
Nothing has changed yet. This won't be implemented till the middle of July.
At that point?
At that point, you will have to update you. If you've got buyers, you'll have to sign broker agreements, and you'll need to use the new listing agreement forms with the updated language. Yes.
Okay.
Last one, Ken. Or sorry, one more, Ken, and then Leanne. Ken. Ken. Okay, Leanne.
Hi, Sam, can you hear me?
I got you.
Okay, so just out of curiosity, I have never personally had a for sale by owner transaction where I represented a buyer, but I'm sure there were sellers in for sale by owners that did not pay a buyer's agent brokerage.
Absolutely.
So how did those buyers agents handle compensation? It's kind of like something in that regard, what we're dealing with now.
If they didn't use a buyer broker agreement, there's the no rep agreement. That's this agreement right here. Show you. Give me 1 second. This form right here.
Yeah.
You can use that if you're just doing a one-time showing. Or and what also has happened in the past is that you're a FSBO, and the buyer's agent calls you up and says, hey, you're a FSBO. I'll bring you a buyer, but pay me a commission. And then the FSBO says yes or no.
Correct.
So that's probably gonna happen more.
Absolutely. Totally. And I appreciate your answer. Thank you very much.
You're very welcome. Okay, so I'm gonna go through the chat one last time, make sure I've answered pretty much everybody's questions. Kim, what are the costs for suing everyone? 0 if you win, a really big number if you lose. Let's see what else we got in here. Yeah, okay, so I'm gonna put out my slides and my video in a couple hours. So don't worry about that. I saw a bunch of people ask about that. And James, I think you're right. It's time to go fishing. All right, everybody. It's been almost 2 hours. I really appreciate you. Go sell some houses and call me with any questions. Take care, and we'll see you soon.